Hi, welcome to my channel. I am Thomas Sim. Today is 20th of April 2022. The topic I am doing today is about person who has passed on or person who has died and how it affects the property registration. Let me go in. Hi, welcome to my channel. I'm Thomas Sim, PA2066. Today, 20th of April 2022. findWHERE series vendor. Under the findWHERE series, property investing and selling issues, 22 chapters. I have one topic on vendor, which actually was split into first half and second half. There was a small topic on people who are holding property as vendor and at the time of terminal ill or passing on, I mean likely not going to live on very long, and what are the available options for the person, how to pass on the property to hand over to the next inheritant person who inherit the property. So the topic I want to add in or an extension for that video presentation under vendor, I would like to do an extension today. So the topic I will do is die. What is next? So if a person has died, what is next? Let me begin. So we have gone to few topics earlier in the 21 chapter and now 22 chapters now. So this extension is for the topic of vendor, under vendor, which is within the block of shelter. Then we also did care, which includes bankers and agents, and investment, dealing with investment under government portfolio, tenants and landlord. And also we talk about business aspect of how to do real estate, especially in estate agency practice. Okay, so nothing is certain but death and taxes. This is a very famous phrase which a lot of time we can't run away from death and taxes. So what would happen in the scenario of your planning your property when it comes to facing with death? So okay, now purchaser or the new owner, supposedly the person just purchased or under construction, consider under construction project sale, let's say project sale. There is no title yet. It's only signing sales and purchase agreement. Well, we understand that this no title doesn't mean that the property cannot be purchased or cannot be due. So this is done under deed of assignment. So now the scenario is the purchaser or the new owner died before the title is issued. So what happens next? What is next? Owner still able to register ownership, or does the owner, because now the owner no more, there is no registration, or the registration is handled in a different mode. So this is the objective of this presentation. We are going in for dissecting how registration and land title is affected when a person actually dies. So in the subsale situation, it's similar. Of course, the subsale situation, the title has been issued. In most cases, title has been issued. But there are also subsale where there is only deed of assignment without the title. Anyway, the simple summary here: sales and purchase agreement signed. The memorandum of transfer also signed by both parties. But then during the time of after 1 week signing the sales and purchase or the memorandum of transfer, the purchaser faced accident and unluckily tragically died, passed on. So assuming that he still want to continue buying the property and the bank would release the loan, so this is an assumption. So if even the insurance is going to pay off the loan, so can the purchaser now who has died actually register the ownership in the land title? So this is what I summarize in the two scenarios. So the first question we're going to ask is this particular case. There's not yet any title issue for this owner. It's just happened that he passed on, he died before title is been registered. So what will happen to him? So what is in the National Land Court in this situation when purchaser died, no issue of title, there was no title in his name. So Part 18, registration of dealings, in the section 292, subpart 4, the death of any person by or on behalf of whom any instrument of dealing has been executed shall not affect the validity thereof. Which means if a person who has started the process of purchasing a property, when all the instrument of dealings, which means the form 14A in the case where it is sales and purchase, or he has signed an instrument of buying a property, sales and purchase agreement, all these instrument of dealings can continue and it shall not be affected by the issue of his death. And any such instrument may accordingly be presented for registration under this part, as if the death of the person had not occurred. So it means that a person who has signed any legal documents on instrument of purchasing a property or dealing in a piece of land, then even though he has died, he passed on, these instruments are still valid to register his ownership of that particular property. Let's look at what is in the case in Sarawak Land Court. Because this one is my own personal interest. Purchaser died, no issuance of title and name of the deceased because the title is not issued. So in the same scenario, section 124, registration in name of deceased person, in the sub 1, the death of any person either before or after the presentation of any instrument executed by him shall not prevent the registration of such instrument, but such instrument may be registered and shall be valid notwithstanding such death. So in this case, in the scenario he purchased from a developer, then he passed on before the release of the title, he actually went through the process, signing the sales and purchase agreement, doing all the legal parts, but then he died. So that doesn't stop him from actually putting his name in the title of the property. A lease or a grant of state land, transfer, charge, or any other instrument may be registered, notwithstanding. Now, to some who are reading law language, notwithstanding, you just substitute it with despite, the word despite. So I read with the word despite. A lease or grant of state land, a transfer, charge, or any other instrument may be registered despite that the person acquiring the interest therein has previously died. So in spite of a person who has died, this purchasing or transfer of the lease of the state land thereby protected, thereby acquired, shall devolve in the like manner as if the instrument had been registered immediately prior to the death. So whether the person died, whichever death is not important, especially when let's say the instrument may be executed, but then the registration of the ownership in the title may be years later. So it will be registered in the name of the person who has died a few years ago. So there is no issue on this part. So not to worry when a person purchased the property, paid up whatever due, and he passed on, the property is in the Land Court, National Land Court and Sarawak Land Court still valid. So now, this is the first scenario where a person has purchased and not yet entered the name in the ownership of the title. Now, what happens if the person already entered the name in the title and after that the person passed on, the person died? So how then the title of the land ownership is being passed on to the future holder, future proprietor? So let me put it into maybe simplified way. We have spoken about this in the case of law relating to the estate distribution. This one I have mentioned it either in vendor or in purchaser, the 21 chapters on the findWHERE series. You can go back and listen to the video. But anyway, the summary of the laws that are related are Probate and Administration Act 1959, Small Estate Distribution Act 1955, and the relevant laws that relates to non-Muslim and also to Muslim. So the Muslim inheritance custom different from the non-Muslim. So the Muslim will follow the different law, Sharia courts. So let me maybe concentrate just on the non-Muslim, non-Muslim. So this is applicable in Sarawak and Sabah and compared to West Malaysia. So Will Act 1959, how to write a will, who can write the will and what are the things that is required in the will. And to distribute the estate, the Distribution Act 1958. So in Sabah it's different. Sabah Wills Ordinance, intestate succession, and for Probate and Administration Act, it is Administration of Estate Ordinance Chapter 80 in Sarawak and the Probate and Administration Ordinance Chapter 109. So first part I explain. Will Act is about how to draft and write a valid will. Distribution Act is about how the estate, how the wealth of the person who has passed on is been distributed by law. That means there is no will. By no will, then you go through this Distribution Act to distribute the wealth to the beneficiary. Then if it is with the will, that means died with the legal will written and not having any defect, then it will follow the Probate and Administration Act 1959. So how to follow? Let us go in. This one I thank to Ma Wen Kai and Associate. I have borrowed their slide. Go to their website for Ma Wen Kai and Associate. There are a lot of good writings there and good summary. So okay, die testate. Die testate means the person who has died with a will. Die with will. Right will, you follow the Wills Act. Governed by Probate and Administration Act for the deceased who died testate, not following Distribution Act. So if a person who with a valid will written and died, and will follow the will. Then they will have the term called executor. So the person who is supposed to execute what is in the will is the executor. So the executor files the information of death certificate, everything to the High Court for a grant of probate. So this grant of probate is issued by the High Court. The executor acts as the personal representative for the person already died. So he is a personal representative. Now this personal representative is also a term used in the land court where a person to eventually inherit the title. So a person who has the next of kin usually who has the position to inherit the property will become the personal representative of the deceased and to file into the land office so that his personal representative can inherit the property. So the grant of probate and issue document of title, other documents that are necessary will be submitted to the registrar of the land office. Saying this will be able to give to the beneficiary. Of course, the executor is not the beneficiary. The executor would present the whole lot of information with the issue document of title and everything, plus the beneficiary name, everything to the High Court, and the High Court will issue the grant of probate, and the probate will be stating who are the beneficiary. So this beneficiary will be given the name given to the land office. So the land office would then lodge the form 14A, which is the same form which is memorandum of transfer, and pay a duty of 10 ringgit for the transfer. So this is for person who has died and with the will written. Now died intestate means person who died without writing a will, and therefore you follow the Distribution Act. So this means that the Distribution Act would govern how the property will be divided. So in the aspect, there is no executor because there is no will. So there will be a personal representative who probably is a son or is a spouse of the deceased to give notice to the court, and then the court would issue a letter of administration. So this personal representative will get this land after issue the letter of administration from the High Court, giving this a letter of administration and issue a document of title and all the beneficiary names to the land office. So this land office would subsequently register using the 14A and stamp duty of 10 ringgit. Of course, there is a lot who are going through the lawyer, going through the legal firm to do this, especially where it has more issues in the family, and especially where no conflict party So a no conflict party, in this case, the lawyer act as a no conflict party to get things sorted out. But if you choose not to do it with the legal firm, then you can self-present. So that channel is to the Small Estate Distribution Act. Under this, any immovable property and also movable, the immovable property must not more than 2 million for this to go through Small Estate Distribution Act. So without a lawyer, so person will present this to the registrar of the this particular office. So this particular office, Small Estate Office, can process the claims for the person who has passed on. So died intestate without will. So what do we see in the National Land Court on this part when person died and the title issue to the person's name when the person died? How is it going to affect? So what are procedure to affect the inheritance? So owner died, the title issue already in his name, and he has passed on. In the law, this actually is grouped under transmission. In the land court, it's called transmission, and transmission usually include three things: death of a holder of the proprietor of the land, in case of bankruptcy, and also in some cases of whereby order of the court to go for sale, usually in an auction. So this means all these three are grouped under transmission. So section 346, registration of personal representative. So when a person passed on in the land court, it says that the personal representative of the person who passed on would have to present this, apply to the registrar under the section to register such him to register personal representative himself as to inherit. So in this case, to get the transfer under here, transfer to his name, to this personal representative's name, as in forming part of that person's estate, the person who is died. Right, what are required transmission in the NLC, the National Land Court, section 346, subsection 2, any such application shall be accompanied by the grant of probate or letter of administration, as we mentioned earlier just now, under the part on Probate and Administration Act. If available, or all the issues of document of title, the land, whereabout, picture, whatever, all the information kept by the deceased person, where applicable, relates to a lease or charge or duplicate ones, passed to the office of the registrar, and other document that is required may be asked by the registrar. Usually, when all these are fulfilled, because the grant of probate or letter of administration come from High Court, so the land office will follow whatever is in the direction of this High Court. Then after that, you take effect. So when will it take effect? So it would take effect as soon as it is registered. No personal representative or representative shall be capable of executing any instrument dealing in expired land until his or the names are entered into the land registry. So is there a gap? So now let's say a person died and then the person passed 3 years to do all sorts of things here. So what would be the effect? The effect is the title, the interest of any personal representative or any representatives registered as such in this law 346 shall, without prejudice to the validity of anything done by any predecessor of his or theirs, relate back to the death of the deceased. So it means with the 3 years just now, when all these things are going on, whoever has done anything also no effect, because the immediate death of the person stops the clock, and then when took 3 years later to register the person's the personal representative name, the 3 years is considered no effect. And that means his name will be registered and redate back to the time of death of the deceased. So there is no gap. So whatever done by the predecessor of his or theirs actually will be no effect. So because it goes back to the time of the death of the deceased. So what is in the Sarawak Land Code on this? Similarly, in Sarawak Land Code, it's called transmissions. So 169, section 169, whenever a proprietor, a chargee, or a sublessee shall die, become bankrupt, or be declared mentally disordered, the representative of such persons shall present to the registrar in Form N instead of Form 14B, 14A. Here is in Sarawak, it's called Form N. In the first schedule, and a written application to be registered as proprietor, chargee or sublessee together with the issue document of title, and such document may be necessary prescribed by the registrar when required. So it's the same, Sarawak and the National Land Court on this matter. If any co-proprietors do not agree, let's say now the deceased is part of a share of 3 persons. Let's say the 2 other persons in the title doesn't agree, what will happen? Can the co-proprietor claims the parts of the interest vested in the deceased? Can the part that the deceased hold actually be taken by the 2 co-proprietors? So in the case of Sarawak Land Court 169 subsection 3, upon the death of any co-proprietor not being a trustee, so co-proprietor's real person who actually has his name in the title is not a trustee. Trustee means that if a person gives to somebody else as a trustee, that somebody else is a trustee, maybe a custody or custodian. Let's say a co-proprietor is a minor. Minor can hold land in Sarawak. Let's say a minor, but then there is a trustee or custodian name. So the custodian passed on has nothing of the effect on the co-proprietor. So here it says that upon the death of any co-proprietor not being a trustee, his undivided shares shall devolve upon his representative. That means his undivided shares in the 1/3 will be given to his personal representative and not upon the surviving co-proprietor or co-proprietors. So it cannot be taken by the other 2 co-proprietors. In this case, I get. So is there any difference between the personal representative differ from the deceased? When the person is a personal representative, when he takes over the land, is there any different from the original deceased? Upon registration, 169 subsection 4 says, pursuant to the 169 subsection 1, which is about transmission to allow to transmit to the new owner, the representative, which is personal representative of the deceased, shall hold the land charge or sublease subject to all equities affecting the same, which means it's the same status as the original owner. For the purpose of any dealing, there is shall be deemed as to be an absolute proprietor. So he has the equal standing as the original owner. So what other conditions are there in transmission? So I said just now, by order of sales and foreclosure in the case of usually in the case of not able to pay the loan, then the High Court or the court gives the order for sale. So both are here, NLC as well as Sarawak Land Court. If a loan given by a lender to a borrower is secured by a charge, and then the borrower who is a charger defaults in making payment, that means didn't pay, then they breach the term. Usually the case of bank taking back, repossess the thing, then the case goes to court. The court would award the successful bidder. Usually go to an auction and bid for the next owner. So the bidder, the successful bidder, will actually inherit or to buy over the property. So this will have a certificate of sale by the court, and this goes to the land office. So the certificate of sales will be treated as for all purpose under the National Land Court as an instrument of dealing, just like Form 14A, or in the case for form of dealing, a form of dealing, or Form N in Sarawak. So my conclusion for this presentation, well, we understand that disease person doesn't affect whatever instrument that has been executed for registration or in the dealings. The person died doesn't mean that whatever he has executed is no more valid. It's still valid. The whole process will go through until his name is entered into the register or the land title. So those thing about transmission we have gone through include the death, bankruptcy, mental disorder, as well as the order by order of sale or foreclosure in the case of people didn't pay their outstanding loans. Personal representative is a person who inherit to take this beneficiary role. Although in some cases personal representative may be executor in the case, but then it is eventually going to also give the grant of probate or letter of administration to the court, to the land office from the court. Will and probate we did mention about tested, and letter of administration will be intested, stamp duty of 10 ringgit. So that's probably a summary for most of the things that I've gone through. Okay, thank you very much. I'm Tom Sim, PA2066. The number is displayed. I have a few websites. findWHERE.info is a geo-linking advertising website. Contract to you a competitive index ranking website. My real property online is my collection of videos as well as my write-up and listings. Abacus Real Estate .fund is a sample website for simple listing, easy to do listing. EstateAgentExam.com is a website for study of the diploma in estate agency by the Board of Valuable Appraisers, Estate Agents and Property Managers. Thank you very much.